Welcome back to the Jurisprudence channel. Thank you for subscribing to this channel. If you find us interesting, please like and comment. If you have just discovered us, do subscribe and click the bell button, to be the first person to be notified about our new creations. If you are not ready to subscribe, your like will be highly appreciated. Today's case is based on the right to life. In this case, the two accused were convicted on 4 counts of murder, 1 count of attempted murder and 1 count of robbery with aggravating circumstances. They were sentenced to death on each of the counts of murder and to long terms of imprisonment on the other counts. On appeal, the Appellate Division, Supreme Court of Appeal, dismissed the appeals against the convictions. The appeal court came to the conclusion that the circumstances of the murders were such that the accused should receive the heaviest sentence permitted, according to law. The trial was concluded before the 1993 Constitution came into force, so the question of the constitutionality of the death sentence did not arise at the trial. The legal issue arose when the counsel for the accused started to argue that Section 277(1) of the Criminal Procedure was not consistent with the 1993 Constitution. This section provided that the death penalty is a competent sentence for murder. Therefore, the matter was brought to the Constitutional Court. The principal arguments against the death penalty or capital punishment were that this sentence is an offense to human dignity, is inconsistent with the unqualified right to life, cannot be corrected in case of error or enforced in a manner that is not arbitrary, and that it invalidates the essential content of the right to life and the other rights that flow from it. However, the Attorney General argued that the death penalty is recognized as a legitimate form of punishment in many parts of the world. It is a deterrent to violent crime, it meets society's need for adequate retribution for heinous offenses, and it is regarded by South African society as an acceptable form of punishment. In the question of whether or not the capital punishment for murder is justifiable, the Attorney General argued that for most serious cases of murder, this punishment should be justified, because it has a greater deterrent effect than life imprisonment. The Attorney General said, it ensures that the worst murderers will not endanger the lives of prisoners and warders, who would be at risk, if the worst of the murderers were to be imprisoned and not executed. And that it also meets the need for retribution which is demanded by society as a response to the high level of crime. In responding, the Attorney General, the court said the question is not whether criminals should go free and be allowed to escape the consequences of their antisocial behavior. But the question is whether the death sentence for murder can legitimately be made part of the South African law. The court also said that South Africans would be deluding themselves if they were made to believe that the execution of the few persons sentenced to death will provide the solution to the unacceptably high rate of crime, because there were far more causes attributable to the high incidence of violent crime. The court concluded by saying that society had outgrown the literal application of the biblical injunction of an eye for an eye, and a tooth for a tooth. The state does not need to engage in the cold and calculated killing of murderers, in order to express moral outrage at their conduct. A very long prison sentence is also a way of expressing outrage and visiting retribution upon the criminal. The court's ruling invalidated Section 277(1) of the Criminal Procedure Act 51 of 1977, which had provided for use of the death penalty, along with any similar provisions in any other law in force in South Africa. The court also forbade the government from carrying out the death sentence on any prisoners awaiting execution. It ruled that they should remain in prison until new sentences were imposed. Section 49 of the latest Criminal Justice Act provides that arresters, normally the police, may use deadly force. That is force that is likely to cause serious bodily harm or death. If the suspect poses a threat of serious violence to the arrestor, or any other person, or when the suspect is suspected on reasonable grounds of having committed a crime involving the infliction, or threatened infliction of serious bodily harm and there are no other reasonable means of effecting the arrest, whether at that time or later, the arresters may use deadly force. Ladies and gentlemen, doesn't this look like a death penalty, which could happen during the arrest? Bear in mind that the suspect during the arrest is innocent, until proven guilty. Can you really say your right to life is guaranteed, and it has no limitations? Or, are you saying your right to life is limited and subject to your resistance on the arrest? What if you did not resist but you have no witness, and the police has a hidden agenda to murder you? Please comment and tell us what you think. Don't forget to like and share with your friends. We are thankful for your support and participation. Forever your law buddy. Until the jury do us apart.